Welcome to the Medical Record Keeping module. I'm Dr. Melanie Fiorella, and with me is Dr. David Bazzo. In this module, we'll be discussing the introduction and legal context of medical records, how to construct a medical record, and appropriate handling of medical records. Doctors Norcross, Bazzo, and Fiorella have nothing to disclose. We'd like to say thank you to the UCSD PACE program, and in particular, Mr. Timothy Blanchard, for lending their curriculum and support to this endeavor. The medical record has several important purposes, not the least of which is your medical legal defense. In this first section, we discuss the function and regulation of medical records and explore the legal considerations associated with keeping a medical record. Now Dr. Bazzo will take us through this section, and we'll be hearing from him again selectively throughout the module.
Thanks, Dr. Fiorella. We're going to start off here by citing a couple of articles that deal with medical professionalism. These are very important because professionalism is something that is being focused on a great deal these days, both with regards to the American Board of Medical Specialties and the Accreditation Council for Graduate Medical Education's core competencies, where professionalism is a very specific trait that physicians must possess and a competency that they need to have in order to be physicians. But it's also important from the medical board standpoint. It's interesting that if you trace back complaints to the medical board, you will actually find that many of them, in fact the majority of them, have to do with professionalism that has been deficient rather than specific medical malpractice or other issues or errors that have occurred. Getting back specifically to these two documents that you have listed here, the ABIM Foundation document and the article from Sylvia and Dick Cruz, really set the tone and the premise of what is anticipated and what is actually expected from physicians with regards to professionalism within our practice of medicine in the scope of society. Today, with regards to professionalism, we're really going to focus in on our duties to keep accurate and adequate medical records and do good documentation with regards to patient care. You will notice that there are links to each of these articles here. You may click on those links and have access to those articles directly. First, we'll start off with the functions of a medical record. First and foremost, the record is meant to capture the interaction that takes place between you and the patient. It becomes the document that one can return to really create what took place when you and that patient were together at that point in time. The next thing that it does is it actually communicates important clinical information. As medicine is now a team sport, there are many people involved in the care of individual patients, and the way the different providers interact can be through the written record. You would be transferring information to other partners, perhaps consultants, or if you're a consultant, back to the primary care physician, also to insurers, and ultimately it becomes a legal document. Whenever a legal situation arises, the first thing that happens is the records are obtained, and it is actually the first point that a person's care of a patient is judged. Therefore, it is really used as the initial tool to measure the clinical performance of yourself as you were taking care of that patient. As we have moved on to electronic health records, there are a number of other functions that are available, including being able to evaluate the care that you're delivering to your populations, to be more proactive about health maintenance and other issues that are pertinent to your patients, which we will touch on further as we get into this module. What you see here on this slide are examples of three separate chart notes. The chart note on the left is one that is illegible, quite short, and doesn't really give a great deal of information. The chart that's in the middle does give a legible documentation about what occurred. However, what's missing here is the detail and the thought process that went into the medical decision making. Basically, the patient here comes in with complaints of chest pain. The examination reveals that the heart and the lungs are normal. The assessment is gastroesophageal reflux. The plan is then to go on to Pepsid and to return as needed. As you can gather here, a great deal of thought and other information went into deciding that this chest pain was not cardiac in nature, was not pulmonary in nature, but in fact was GI in nature. Yet this chart does not capture the thought process or decision making that went in here. The final chart note that you see here is a beautifully typewritten, very legible note that appears to have a great deal of detail within the note. However, I do not want to give the impression that this is what we all want to strive towards. In fact, there may be notes that contain too much information, and the pertinent information does get lost in the sea of unnecessary or perhaps not useful information. This is particularly true with the advent of the electronic health record, where it is very easy to import a great deal of information and wonderful documentation, although it may not be relevant to the specific issues that are at hand during that patient visit. Really, again, what we're trying to do is to reach a balance where we adequately and accurately document that took place while we were there with the patient. We are able to follow a logical thought process that led us from the information from history taking, the details from the physical exam, and how we use those in formulating the assessment for the patient and ultimately coming up with a plan for that particular issue that was evaluated at that visit. As we move on into the next segment of this module, we're going to be discussing some basic legal issues. We're going to be talking about confidentiality and privacy, specifically about HIPAA privacy regulations. We'll be touching on malpractice risks and then end up with the false claims exposure information. This set of information that we're going to cover applies to other pieces of documentation that would reside within a patient's chart. Specifically, we're talking about work excuses, school notes, forms that we complete for patients to give them workers' compensation or disability. These two are held to the same standards as other documentation within the record. Unless you have specifically evaluated that patient for the condition that they are asking you to write a note for, you really must refrain from writing that note. By you making this statement and having your signature on there, you are indicating that the foregoing was true and accurate and independently determined by your evaluation of that patient. It's important for us to document how to change a medical record once it has been created, because actually altering or modifying the medical record after the fact is prosecuted very strongly. You see here we have documented the specific business and professions codes that are here in California. However, there are very similar codes in other states and other jurisdictions as well. Perhaps I can give an example of an occurrence that I had heard of in one of the medical record keeping courses that we have put on. There was a particular practitioner who had listed the date that he saw the patient, left the area blank, and then the next time he saw the patient put in another date, leaving some blank space in between there. It came that one of his patients brought suit against this physician, and the physician then went back and filled in all of the information at a later date. When it came time to the legal proceedings, the opposing counsel had asked the physician's attorney if they were sure that they wanted to proceed with the case. The physician's attorney then asked the physician if there was anything that they needed to be aware of. The physician said no, and then they proceeded on to the case. When they came to trial, the records were produced by the physician that were complete and had a great deal of information. However, unbeknownst to the physician, the patient had copies of the records made that the physician was unaware of, and they were able to produce legal documentation that there was no documentation, in fact, in the records at the time the copies were made, and all of the other documentation was made subsequently. You can see that even though the physician did document accurately in the chart notes, it completely discredited this physician, and the verdict went toward the plaintiff in this particular case. Later in this module, you will be hearing about the proper way to make corrections, additions, and deletions to the medical record. With regard to the information here, there are not really any true, specific, one-stop shop places that you can go to find all of the regulation for any kind of medical record. Medicare may have some specific guidelines, particularly in their condition of participation. There could be standards of practice that exist within the hospital that you are working in, or perhaps in the medical group you are working in, that are dictated by the bylaws. There may be accreditation standards that need to be met. But the problem is that you can't really go to one particular place and find out all of the information you need with regard to the requirement for the medical record keeping specific to the area that you're going to be practicing in. I think an important general rule to follow is that if you do follow Medicare guidelines, you'll generally be on pretty safe ground. Many requirements and many organizations do follow the path that Medicare and CMS tracks for them. And if there were one specific guideline that you wanted to follow and again be safe in most particular areas, it would be the Medicare guidelines. Okay, claims form certification. This is the documentation that is necessary in order for you to get paid by Medicare. Now, the thing about Medicare is that all insurances, well, I won't say all insurances, but almost all insurances fall in line with what Medicare requirements are. And so, Medicare has come up with the CMS Form 1500, which is the claim form where you put the diagnosis, the billing code, and enter the amount that you're actually going to charge. And these certifications become legal documents because when you sign these, this is attestation that everything that happened that I'm billing for is true and honest and took place. So again, it's very important to make sure that it is accurate. For those of you that use a billing service and feel that you can trust them and that they would take on the liability if something is incorrect, this is actually a false assumption. Because it's your signature on there and they're billing for your services, you are the one that's on the hook for the accuracy of all of these. So it really behooves you to know that you have a good billing service, if you do in fact use one, and make sure that you audit them every once in a while to make sure that they are doing a reasonable job at submitting your billing so that you don't get into trouble. Other legal issues that have become relevant with regards to the medical record and documentation is the idea of confidentiality and privacy. Specifically, now we're going to talk a little bit about HIPAA privacy regulations. It was in 2003 that HIPAA compliance was mandatory. What this actually means is that we need to be very good custodians of the record. We need to be able to maintain the confidentiality of the medical information regarding our patient. We have to make sure that the records only go to those people that need the information and not anywhere else. The website that you see listed there in the link has all of these specific details with regards to HIPAA regulations that are currently in effect. The bottom line is that the records do need to be stored in a locked area where access is limited to only those people that need access, and that records are not released without strict and specific consent from the patient or the person that is responsible for the patient. The next topic we're going to talk about has to do with malpractice exposure. This is an important thing to discuss because most physicians don't even know that they are going to be sued before the request for records has come in. Typically what happens is a request for records comes into the office. The staff members dutifully copy the records and send them off to the requesting entity, and then the records are reviewed. It is not until later that if a suit is to come up that the physician is then informed. At the initial record review, a determination is made as to whether the care that was delivered to the patient was appropriate or not. If the records are good and can stand by themselves and document the interaction that took place that was reasonable, necessary, and appropriate, many times the case will end right there. Conversely, if the records are poor, the documentation is poor, and there is inadequate information, there is great room for interpretation, which then makes the liability for the physician go up exponentially. Therefore, I think it's pretty easy to see that the quality of records can actually make the difference between a case moving forward or whether the action goes no further. One of the things that's important is to be wary of why you're documenting something. Are you documenting truly the objective findings for a patient and the condition of the patient, or are you documenting to make a point in the chart or perhaps justify why you had taken a certain course of action when perhaps another provider who is caring for the patient has recommended another course of action? You really need to be careful about having chart warfare go on in the medical record. If turf issues do arise, the chart is not the place to document that. You really need to be objective in your documentation. Try not to editorialize, and just ask yourself, is this medically necessary to be in the chart or not? Okay, let's talk about physician discipline by state medical boards. This is very different from malpractice, and I think all of us are familiar with or have heard of what happens in malpractice cases. Now, what happens when a state medical board disciplines us is quite different. Unlike malpractice suits, which can be confidential and closed, the item or the processes that occurred during a medical board proceeding are actually all public knowledge. As a matter of fact, you can usually go to your medical board's website, type in your favorite physician's name or your own name, and see what has happened as a matter of public record, specifically with regard to any disciplinary actions. The other thing about this, like any other legal proceeding, is that there are lawyers involved. A lot of times, physicians will have lawyers representing them when it comes to medical board issues. And unfortunately, this is not like malpractice where you have an insurance carrier that will cover this. The people that represent you in these matters are very important. However, this can also be a very big hit on your wallet. Another important point to make with medical board referrals does have to do with malpractice suits, and I'll give the example here in California. If a suit is settled for over $30,000, it automatically gets reported to the medical board, and they determine whether a case file needs to be started and a separate investigation. If it is settled for $29,999.99, it does not get referred to the medical board. Now, if a case does go to the medical board where it becomes serious, this could actually affect your license and your ability to practice. The medical board does have the ability to revoke a license, put restrictions on your license, and really affect your ability to continue as a physician. When we talk about false claims exposure, it's important to us to understand just the depth that these claims can affect us. This is an area that has recently gotten quite a bit of press due to the fact that a number of physicians have recently been prosecuted for Medicare and or Medicaid fraud. We hear that prosecution has been very strict in going after the physicians and retaining and recovering a great deal of money. This is really based on reviewing the records to determine if the payment that has gone out has been justified by what is documented in the chart note. If it is not, then an investigation is started, and the entity, whether it be Medicare or Medicaid, goes after the physician and attempts to recuperate the money. If you are prosecuted and found guilty of filing a false claim, the penalties associated with that are triple the amount of what was actually recovered from you on that particular claim. The minimum amount that is currently charged for False Claims Act is $5,500 up to $11,000 of civil penalty. And again, it's important to remember that this is for each and every claim. Each and every CPT code that you submit that was a false claim actually can be tripled, and so pretty soon you see that you're talking about serious amounts of money if any of these claims come against you. I think all of us are familiar with the Affordable Care Act, specifically termed PPACA, and one of the important points of this act is the recovery against fraud. The government has decided that as part of cost-saving measures, they're going to be more aggressive about going after fraudulent cases and perhaps start to look at things that just have the appearance of fraud, though not necessarily fraud. This is going to be important to you because if you have documentation that isn't quite up to standard, this gives an indication to a reviewer that fraud may be occurring. Even though fraud is not occurring and not taking place here, it does put you at higher risk for investigation, and that is a place that certainly none of us want to be. Now, with this idea of knows or should know, a lot of people who are convicted of fraud never had any intent of committing fraud because we just sometimes make mistakes. Unfortunately, that's not an excuse, and it's not going to get you off, because not knowing is considered reckless disregard and in some cases deliberate ignorance. So ignorance of the law doesn't necessarily excuse you. And of course, the intent to defraud is never really required in this particular situation. It's just the fact that it happened. So you can be sorry, but it's not going to get you off the hook. So it's good that we're talking about this here in this module, because a little bit of understanding can avoid big problems later on. Most of the times when we're submitting claims, it's going to be for personal services that we have rendered to the patients. However, if you are to work with a locums who is going to come in and cover your practice for a while, it's good to know that you are actually responsible for those claims of the locums that you hire. The claims actually go in under your name, even though the locums is working for you, and you are therefore responsible for these. It would be a good idea to make sure to review some of these claims and that the person you have hired as your locums is doing a good job and a diligent job at their documentation so that the claims don't come back as fraudulent at a later time. Another key point here with regards to payment from the federal government is that if you are overpaid, it is your responsibility to return those overpayments to the federal government. If you retain overpayments, that can be considered a fraudulent act and is illegal. Quitam is the shortened version of a long Latin phrase that means as much as the king as for me. And essentially these are the whistleblower suits where a person will notify the government that there has been fraud that has taken place, and this then leads to a prosecution. Basically, when a suit moves forward in a whistleblower fashion, the person who blew the whistle essentially gets to retain and keep up to 50% of what is collected. These suits are generally not known until they are well into the investigation. They are filed under seal. The government does have 60 days to review these suits initially. However, that is almost always extended. And the unfortunate thing for the person that is being investigated is that they do not know till very late into the process. Now, it's important to note that with many of these qui tam suits, that they are typically ex-employees, ex-spouses, or some type of ex in general, whether it's an ex-partner or someone who may have an axe to grind that has access to a great deal of information. And again, this makes the prosecution much more damaging to the individual. This next slide here is meant to inform you of particular areas that CMS have been reviewing with extra added scrutiny in the recent time period. In particular, they have been looking at evaluation and management services, psychiatric behavioral health, anesthesia and in particular pain management, physical medicine and rehabilitation, critical care services, ICD-9 coding specifically as it relates to medical necessity of orders, and finally countersignatures of both verbal orders and also allied health professional orders. Now, it's important to be forewarned about this because if you or your style of practice falls into one of these categories, you need to know that you are under a higher level of scrutiny at this time, and it really behooves you to make sure that your documentation is extra careful so that you do not end up in an audit or some other further type of review that would put you at risk.
Thus far, we have discussed an overview of keeping a good medical record, regulation of the medical record, and why this is so important from a legal aspect. Now we're going to switch gears a bit and focus more on the nuts and bolts of keeping a good medical record. This will include discussing formatting, types of documentation issues, and appropriate ways to correct errors.
One of the important things to recognize as we start our discussion on documentation is that it is very difficult for physicians to be able to go to one place and find the criteria that is recognized throughout the land. What you see here is that there are a number of different organizations, including the American Medical Association, the American Hospital Association, CMS, etc., that have guidelines with regards to medical records. There are some commonalities, however, that exist between these guidelines. First is that the charts must be legible and complete. Each encounter should include the date and the reason for the encounter. There needs to be an adequate history and physical exam documentation, in addition to any results that might have been available during the assessment and planning the care for the patient. All entries must be dated and authenticated. The past and present diagnoses do need to be accessible somewhere in the chart. The relevant health risks do need to be identified, and the patient's progress with response to treatment, changes in diagnosis, their adherence or non-adherence to medications, etc., does need to be documented. In addition, it's important to try to capture your medical decision-making and your reason for running diagnostic tests and what led you to your assessments and conclusions. In addition, when required, it's important to document the informed consent discussion that you have with the patient. A slight aside here with regards to informed consent, it's important to realize that an informed consent is actually not a document that is signed and legalized when a patient puts their signature on it or you put your signature on it. The informed consent actually consists of the discussion that takes place between you and the patient, and the documentation of the informed consent really is just meant to capture what took place during your conversation. In addition, you should make sure to document any medical decision making that you used during this process and then encounter with the patient, and either the CPT code and or the ICD-9, soon to be ICD-10 codes that are billed should really reflect the documentation that you have listed in the chart. This has been an area that has led to audit in the past and needs to be cared for and looked at closely.
So briefly, just to circle back to the law once more, I wanted to point out that the terms accurate and adequate or consistent are actually written into the letter of the law. Here we have a code taken from the Medical Board of California, but most states follow very similar wording. When it comes to accuracy, truthfulness logically follows. And this seems like a simple concept and very obvious, but actually now in the era of electronic health records, it's a little more tricky. To be truthful, you need to document what the patient actually said, using quotations where appropriate, and document an exam that reflects only what was examined. This is obvious, but it becomes easy to overlook this. Frequently, physicians will use the copy and paste feature to bring in pertinent details from prior notes, their own notes or those of others. This is okay, but it needs to be clear to the reader that this was done, and it should be relevant to the point of the day's visit. This also comes up when we're using pre-formatted notes. Lastly, if something was left out and remembered later, we need to note that in an addendum and document any remediation of the plans. So when we're discussing the medical record, what are we actually referring to? Frequently, people think of the office note. However, the medical record encompasses history and physicals, inpatient notes, discharge summaries, lab reviews, as well as work, school, and travel excuses. So another aspect of keeping a good medical record, in addition to being accurate and consistent, is it needs to be comprehensive. And the office visit for a new patient offers an opportunity to capture all of this information. At the new patient office visit, one would note the patient's chief complaint for that day if they have one, and any recent history of present illness. But importantly, here needs to be noted their past medical history, any pertinent surgical history, all of their family history should be captured at this visit, a full review of systems from head to toe, noting all of the negatives in addition to the positives. Generally, a complete physical exam is performed, although not always. Any prior labs that can be brought in from the outside, and then an assessment of their overall state of health if there's nothing pertinent today, and a plan going forward. And we just highlight this as it is a bit different from the next chart note that we will discuss. I think it's important to take a moment to discuss the SOAP note, which is the most common format used in daily office visits. And most practitioners have some experience using this format. The common mistakes here are mixing up the information that goes under each section. So the S's are subjective, and here it's important to note what the patient is there for in their words. Commonly in this section, you will find information above and beyond what the patient, him or herself, has conveyed. The objective section is where you are going to note your clinical observations. So the vital signs, how the patient appears to you that day, what your findings of your physical exam are, and also any review of lab values that were previously done or x-rays with your own interpretation, not simply just put in the note. Diagnosis or assessment is putting those sections together, what you think is actually going on. And P is the treatment plan and what you're going to do with that information. It bears taking a moment to review this. Again, as I said, this is an area where frequently when we're rushed, we mix up the information that's in each section. Another point about SOAP notes is frequently patients come in with multiple issues. And each issue needs to have its own subsection in the subjective, again in the patient's words. And anything that's mentioned in the subjective needs to be carried through logically throughout the objective section, assessment, and plan. Commonly, something will be left out by the end of the note. The charts on this slide are examples of common documentation problems that I briefly described in the previous slide. Chart A is an example of the subjective and the assessment not correlating. Here, the subjective describes the patient as presenting with anxiety and PTSD. And then if we scroll down to the assessment, it's hyperlipidemia. The objective does not give us a pathway to evaluate the physician's thought process. And it's possible, based on the normal psychiatric exam, that the exam was copied and pasted in. Chart B offers several discussion points. In this chart, there is a lack of detail in the subjective section. The author notes there's pain in the left leg, but there is no qualifying information such as where is the pain located, what causes the pain, what alleviates the pain, and what type of pain is it. Then if we move up to the objective section, there are diagnoses listed rather than actual descriptions of the physician's findings. Generally, what we would find here on a musculoskeletal exam would be tenderness, or a neurologic exam such as weakness, numbness, or anything that's found with provocative testing. And then we follow down to the assessment section, continue regular medication. We don't know what these medications are for. Manage hypertension, but this is the first time this is mentioned. And then pain management, but there's no description of what the management entails, the current status of the patient's pain, is it stable or worse, and what the follow-up plan will be. So one of the benefits of an electronic health record is that we have the option to use pre-formatted templates. This definitely saves time, improves our efficiency, and can make us more accurate. But here we're going to discuss some of the pitfalls to watch out for. So we discussed briefly the copy-paste function where you're bringing in prior information or information from other physicians' notes to bolster your note for the day. And as I said before, that's definitely appropriate and can be very useful as long as it's documented clearly that this has been done. This also comes into play when you're using pre-written phrases or pre-written exams. You need to make sure you go back in and assure that they are accurate and truthful for the exam that was done that day. Two other options that come up frequently are checkboxes and pull-down lists. These are quite helpful because they assure that you'll go through and answer the questions that pertain to that day's visit. So all of these have potential benefits as long as you avoid the pitfalls that can come with them. So this is an example of how templates can lead to insufficient information. Here, the subjective and objective sections don't provide enough information to determine how the physician came to his assessment and plan. The subjective section is sparse and doesn't give any information about interval history from the last visit. It does note that this is a follow-up, but we don't know how the patient is feeling that day or if any new concerns have arisen. The objective section is a template format where the physician has checked off all of the exam components that were examined. Here they're all normal. However, I don't understand from this note why some of these were examined. And then following from the objective, we get down to the diagnosis of elevated blood pressure and high cholesterol, though he does note that the blood pressure was normal at this visit. And then prescriptions, we don't know if these are new, if the doses have changed, or if they're a continuation of prior therapy. So as we discussed earlier in this presentation, charts must be legible to ensure that they're accurate. If you can't read it, the entry is considered not to exist. Another point is if you use dictation, it's not sufficient to simply dictate the note. You must go back, read the dictation, and sign off on it. If that has not been done, it's not a legal entry. Now, the other aspect of keeping a good medical record is consistency. This means you have the same high-quality medical record maintained over time and throughout the record. To achieve this, establishing a framework or system that is comfortable for you will ensure that each time you document, you'll produce a logical and thorough medical record. Another aspect of keeping a good medical record that directly affects accuracy is the timeliness of your entries. Data shows that we don't remember as well as we think we do, and the increased duration of time from an encounter to when we actually record it greatly affects the accuracy. In addition, that duration of time, should your medical record come under the scrutiny of law, will decrease your credibility. So to summarize the common documentation issues, there can be insufficient or frequently too much information now that we're using the electronic health record, and the stylized fill-in-the-blank or use of templates can really lead to some of these problems if they're not used mindfully. In some cases, there can be specific data missing, or the data that's there doesn't support the claim or the diagnosis that's made. And of course, if something is illegible or unclear, it's not an accurate and consistent medical record. So what we've discussed so far is common sense. Our medical record needs to be accurate, truthful, and done on time. And most of us start the day with those intentions. But how many of us have gotten to the office a bit later than we had hoped, already behind with patient phone calls and labs that need to be followed up? By the end of the day, taking care of your patients and any urgent issues that have come up have basically left little time to take care of good medical record keeping. A lot of times we have other things on our mind. And, let's face it, actually writing out what happened during the day isn't always the most enjoyable aspect of our medical practice. So all of these and probably others that come to your mind are key issues that can lead us all to be vulnerable to occasionally poor documentation or late documentation. And another point I wanted to address is mindless here is in quotes. There is an emerging field of mindfulness and how it relates to our practice of medicine. Many of us get through the day by proceduralizing or habitualizing routine and commonly occurring activities, such as even patient encounters, writing notes. And, in many of these cases, it's beneficial. But when you're sitting in front of a patient, it's mindful practice that will help support good patient care and good medical record keeping. And there are many techniques that can be learned in this field to help you minimize the effects of proceduralizing or habitualizing your patient care. So this slide is put in here to point out that fraud is more often than not unintentional. Dr. Bazo brought up the phrase knows or should know as a part of the law. And here's an example of where fraud could be committed unintentionally. For instance, going back into the medical record and noting something that happened as if it were that day, when in fact you're noting it several days later, or going in and deleting out an item and overwriting it so that the prior information is no longer legible. So in order to avoid unintentionally committing fraud, we need to know how to correct errors appropriately. For the paper chart, the line out method is drawing a horizontal line through the erroneous information so that it's still legible, rather than erasing or obliterating the information completely. Another option is to use addenda, which is writing in the next available space in the chart rather than squeezing in the margins or overwriting information in the previous note. And you just need to be sure that you date and time the entry and note to what it refers. With regards to the electronic health record, it can be tempting to go back to a note and delete and correct information. However, this is actually fraudulent, and this also needs to be done with addendum. So you can start a new progress note, or you can continue in the same note, but just do the addenda format where you have a new date and time. And it is important to note that most electronic health records automatically date and time your entries. So even though the information appears unchanged, it is evident that there were prior copies made.
On this next slide, we're going to highlight an example where it's important to note that orders such as tests and other procedures that may occur need documentation to show why they are necessary. In this particular case, the Inspector General reviewed a particular physician's chart notes. They found that the same tests, including hemoglobin, hematocrit, urinalysis, blood glucose, were ordered for just about every patient at every visit. However, the documentation that was accompanying those particular chart entries did not indicate the reason why the tests were being done with such frequency and why they were being done for each of these patients. This led to the physician ordering and charging for unnecessary tests, and prosecution then went forward in that the physician was held liable for ordering these tests and that payment was not necessary and was actually fraudulent and was then recouped, again with the subsequent penalties that accompany these.
With regards to the whole chart, this slide is just to note that going along with the theme of consistency, everything needs to be comprehensive. Overall, there should be an organized structure. All key patient communications need to be included, as well as the SOAP notes and the new patient notes. And anytime you review an x-ray or a lab, some sort of documentation with regards to your findings needs to be included in your note and in your chart. Anytime you communicate with a patient, that communication needs to be documented in the chart. This slide specifically refers to informed consent. And the key here is that your documentation reflects the fact that the patient understands his condition or treatment plan, the risks and benefits and alternatives to what you're offering, and that they agree to take on those risks with a plan that you've proposed. Informed consent is frequently associated with procedures or diagnostic tests, but frequently when we see patients, we are prescribing medications, and that also needs to be documented in your chart, that you've noted the risks and benefits to the medication, potential side effects or interactions with other drugs, and again, that the patient understands what you've told them and that they've agreed to carry out taking the medication. This slide is to remind us that all communication with patients need to be officially entered in the medical record. For instance, telephone and email communications need to somehow find their way into the record, either directly or going in and entering it as a separate note. And a note here, be cautious about giving advice outside of an appointment time unless you are going to go in and do a brief SOAP note format relating that there's been an exchange of information, and again, that any informed consent that would have been required is also documented in the note. A note about surgical reports. The main issue here is they need to be done promptly and comprehensively so that someone can go back and sort of experience what happened in the operating room. And each hospital system has its own requirements, so I would refer you to your own system to get the guidelines on when reports need to be dictated and any other pertinent regulations. A quick note about anesthesia. They should have their own note, a pre- and post-operative note that reflects the status of the patient and anything that went on intraoperatively. We've touched on this a few times, but some specific issues related to diagnostic services are that your notes need to support why the tests were done, need to reflect the fact that they were actually interpreted and what action might have been taken based on the results, and that they haven't been ordered redundantly. And again, this all needs to be done in a timely manner. Now that we've discussed the legal aspects of medical records and how to keep a good medical record, we're going to turn our attention to handling those records. With regards to obtaining old records, when a physician receives a request to transfer medical records to a new physician, they are required to respond to that request promptly, but only with the patient's permission. And a note here back to the law is that a physician may be sued for disclosing patient information if the patient hasn't expressly given written permission. Verbal permission generally does not hold up in court. And I'll refer you back to the HIPAA guidelines for full details about these requirements. Receiving a subpoena can always be nerve-wracking, so I wanted to review some important points with regards to receiving a subpoena for medical records. When a physician receives a subpoena, they need not surrender the original documents. I recommend that you talk with risk management in your clinical setting prior to releasing any records or copies of records. You are able to provide certified copies as the original medical record is the property of the physician. And just to note, you may be asked to produce originals for inspection. With regards to how long medical records need to be retained, for active patients that are ongoing, the record should be retained indefinitely. For inactive patients, a 10-year retention period is advised. The California Medical Board recommends that physicians retain all records for a minimum of 7 years, but please refer to your state law for your own particular requirements. Regarding the retention of medical records for minor patients, most states agree that the record should be kept until the patient reaches the age of majority, which in California is 18. However, there could be some caveats, such as in California, there's an additional 7-year requirement. Again, please refer to your state board for your own state requirements. So to summarize, we've gone through quite a bit of material. We've covered the function of a medical record, the regulatory bodies overseeing the medical record, common pitfalls of documentation, and legal ramifications of those pitfalls. We've discussed the required components and format of a complete medical record, and also the handling and retention of medical records. We know this has been a lot of material. We hope it's been useful and that you'll be able to apply much of this to your clinical practice.